Well, I've practiced patent law for about 30 years. And in the second half of my career, I focused on post-grant proceedings and built that on a foundation of prosecution work. There was a case in 2008, In re Swanson, that really boosted the importance of reexamination. It really provided a second bite at the apple for a litigant. As the implications of that case unfolded, reexamination really became much more important to litigation strategies. And I was focusing on reexamination, so that had a big impact on my practice. And then after the American Invents Act passed in 2011, that had an even bigger impact. And the central aspects of that went live in September 2012 and then March 2013. And so demand really exploded for those that had experience related to post-grant proceedings. And in 2013, I left the partnership of a large regional general practice firm, went to one of the largest patent boutiques in DC, and there I focused exclusively on inter partes review proceedings and some other post-grant proceedings, reexamination and reissue. And that was an era where there were a lot of critical cases that were establishing the procedures that we now use for IPRs and PGRs. And in 2017, Matt Phillips and I saw the need for a micro boutique that could work with litigation counsel. And that's been our practice now since then, focusing on post-grant proceedings and also doing some prosecution work. I also enjoy teaching and writing about post-grant proceedings. Matt and I co-authored a treatise on reexamination and reissue practice in 2008. And that morphed into a two-volume treatise on post-grant proceedings. We provided that treatise in conjunction with CLE courses that we taught for over a decade with the Patent Resources Group. Also, I started teaching a course on post-grant proceedings as an adjunct professor at the George Washington University Law School in 2015. And I've enjoyed being a co-instructor for that course since then.